My name is Nancy Champlin. I use she and her pronouns, and I'm the executive director at Southeast Uplift Neighborhood Coalition. And for those of you that are new to Southeast Uplift, we collaborate with the Southeast Portland community to build informed, inclusive, and participatory neighborhoods that support our social and ecological well-being. We, of course, joyfully also support neighborhoods in Northeast Portland that are south of I-84. Here at Southeast Uplift, we envision a more resilient future for our communities where everyone feels and is welcome, interconnected, and empowered with the resources needed to advocate for change on the issues that impact their lives. Before I jump in and introduce you to one of the most valuable resources in the nonprofit community here in the Pacific Northwest and beyond, just some housekeeping notes. As you know, this webinar is being recorded. Everyone will get a copy of the link when it's available. If you have any questions during tonight's presentation, feel free to jump in, raise your hand, or just pop in. You can also drop it in the chat if you would like. We have allotted a generous 90 minutes to this training, so don't be shy. If you've got a question, just come right out with it. Well, now I'm going to introduce the star of our show. Without further ado, I'm pleased to introduce to you tonight to our trainer, David Atkin. David is the founder and the director of the Center for Nonprofit Law. He's been deeply involved in the nonprofit sector for over 40 years and has worked with thousands of nonprofits. David's a recognized expert on nonprofit law. He's helped coordinate the Oregon State Bar's continuing legal education seminars on advising nonprofit corporations, and he regularly gives specialized seminars for professionals that advise or lead nonprofit organizations. We are so grateful for you to be here, David, tonight. Thank you for helping us to demystify nonprofit bylaws.
You are very welcome, and it's really such a pleasure to be here. So I want to start by just inviting everyone here to please don't be shy, jump in, ask questions, don't save them to the end. They'll come out much better if we have questions and answers as we go along. And we're a small group. It is going to be helpful if we view this as a conversation and go back and forth with questions as we go through. This isn't something I admit to people out on the streets because they might think I'm a little bit odd, but I have to say, I actually, after 30 some years of reading, writing, reviewing, and editing bylaws on a daily basis, I enjoy it. And it's a little nerdy, that's true. But what I enjoy about it is that there is really so much flexibility and so many options and so much room for creativity in writing bylaws. And the bylaws become hugely important, setting the way that the organization is structured, roles and relationships, setting out responsibilities and obligations, checks and balances, and setting out even the organizational culture that you want to have. And so with that in mind, I have helped literally thousands and thousands of groups write bylaws and review and amend them as needed. And what I hope to do today is just be able to converse with you, answer questions about all of your own bylaws, so we can focus in on that. I may occasionally pause for a moment while I look up specific parts of the statute to read to you if that's relevant for some of the questions. When you're writing bylaws, it's helpful to see where they fit in the kind of the content architecture of the legal authorities that nonprofit corporations have to follow. So that hierarchy of legal authority begins with, due to the supremacy clause of the Constitution, the federal laws and federal laws and Irish regulations rather are supreme in what they cover is the ultimate authority. Below that then comes state law. Below state law then comes your own articles of incorporation. They supersede everything that's below that in the hierarchy of authority, which means that anything in your articles supersedes what's in your bylaws if they happen to both have something that covers the same topic. So it's important to know that whenever you look at bylaws, review them, or write them, you want to know what's in the articles first to make sure you're not setting up contradictions with them. The articles, the purpose of them is primarily just to make it clear when you incorporate what type of organization is it? Is it a partnership, an LLC, or corporation? So we're dealing here with corporations. Then what type of corporation? Well, it's a nonprofit corporation. And then the articles lay out, well, what type of nonprofit corporation? Well, it's either a public benefit, mutual benefit, or religious. And the rules and requirements and restrictions and registration are different for each of those three types of nonprofits. So you may be involved in some nonprofits that are not public benefit 501c3 types and following a different set of rules on many of these things we'll discuss tonight. So your articles lay out what type of entity it is and some of the basic issues with structure. And then the bylaws really cover governance, how the organization is governed, who can serve on the board of directors, who selects them, how they're selected, are there members who have the power to elect and remove the board, or what other powers do the members have? The bylaws set out how the board does its work and makes its decisions, how the members do their work and make their decisions, if there are voting members, and then sets out the roles and responsibility of the directors and officers, and then covers a variety of related topics, usually ending with a provision for how you amend bylaws. And amending bylaws is a kind of a process that boards should consider regularly, looking to see, are there changes in their needs, changes in their circumstances, changes in their capacity that would indicate it's time to update them. Also, there's changes in the law, and bylaws need updated every once in a while to accommodate those changes in the law. After the articles and bylaws, which are referred to as your governing documents, then we get down to the organization's policies. Policies can be set by either the board, who should adopt and approve the most important of your policies, but policies can also be set by the executive director of a nonprofit and still be binding on all of the staff and the organization and how it does its work. So policies are then below the bylaws in that hierarchy of authority. So we have to make sure that nothing in a policy would contradict anything that's in your bylaws. Because of that, it's helpful to make sure your bylaws don't get down too deeply into the nitty-gritty details in some areas, because policies are able to make it much easier for you to be flexible, to make changes. Bylaws, when you amend them, they have to go through somewhat of a cumbersome process, with your voting members approving some or all of the amendments, your board able to approve others. And then once you amend bylaws, you have to then notify the IRS and the Department of Justice and send them your new bylaws. Whereas policies can be amended without that burdensome and sometimes lengthy process, and don't have to be sent off with to the IRS and the Department of Justice. So one of the things that's important is making sure your bylaws contain everything they need, but don't contain things that aren't really supposed to be there. So you wouldn't want to see your policies on, the nitty-gritty details of perhaps your nomination election process. Some of that should be in a policy. You wouldn't necessarily want your policies like financial policies, financial control policies, safety policies. You wouldn't want to have personnel policies in your bylaws. Policies really are for all of these kinds of other topics. Bylaws are really about how the organization is governed and how the people that govern it, your board of directors, are selected and how they operate. And then finally, an organization is also bound by the contracts and agreements, memorandums of understanding, and other forms of agreements that they have with other organizations and other people and entities. So that's a kind of a quick look at the legal authorities and legal documents that you have to abide by, be aware of, and know the contents of in order to be sure you're following the proper rules for nonprofits. Okay, with that in mind, today we'll be talking about the bylaw rules and requirements and what's allowed and available for public benefit nonprofit corporations with 501c3 status. As I said, the state largely governs the structure and nature of the corporation and the governance of it. Federal law at the top of the hierarchy generally regulates almost entirely your activities and programs, what you can do, what you can't do, what you can spend money on, what you can't, how to raise money legally. Federal law generally covers almost nothing but your activities and programs, the do's and don'ts. State law then is where you look for your bylaws, and that's in Chapter 65 called the Oregon Nonprofit Corporation Act. Okay, I'd love to pause here for a moment, and then with that kind of just a context, if any of you have come to the meeting with questions you'd like answered, I'd love to get them out of here at the beginning, and then we can figure out where the best place to bring them in is, and I'll write down notes. Also make sure you don't fail to ask as we go along. So does anyone here have any issues or questions they want to make sure we cover today?
Yes.
Speak now and I'll write them down.
Okay, I'm Uta Munger. I am the treasurer of a non-profit. We are not a 501c3. Do we still have to have bylaws?
Good question.
I
your
only
neighborhood
ask good questions.
A neighborhood association?
I'm sorry.
Your neighborhood association?
Well, this is not for the neighborhood association. I'm with South Tabor or Tabor Villa, I guess, because we don't have
Okay.
an in South Tabor. I'm the treasurer of a group called the League of Swedish Societies, which I would consider the mother of 6 children. And there are 6 Swedish organizations here in the Portland area that the league, which I am part of, most of the children are 501c3, but the league is not. So my question then is, why do we exist in the first place? And are we legally existing?
Excellent question. Okay. And I'm going to write down the other questions and then come back to that one. Okay, other questions that anyone has?
Looks like Stacy and Stephanie both have their hands up.
Oh, good.
And
Stacy,
Roger.
Stacy, why don't you jump right in?
Hi, I'm not sure if this question or situation that I'll describe is anything that we could necessarily incorporate into our bylaws, but we recently had a very challenging several months after the resignation of a board member who had not shared credentials for all of our a lot of our digital accounts. So he basically was holding our digital property hostage. And we don't have anything in our bylaws specifically for preventing that from happening or having like a roles and responsibilities of sharing or documenting that. I guess basically it came down to we had some sloppy record keeping and we should have been holding each other more accountable for having backup. But it got to the point where we were on the verge of seeking legal, ready to take legal action. And I'm wondering, had we had anything in our bylaws or just been more careful, I guess. We definitely learned a hard lesson with this. I mean, we finally did get the credentials, but it crippled us from communicating with our neighborhood for many months. I mean, we lost the ability to use our email list and lost the ability to get into certain accounts, which were the reset accounts for several of our email accounts, and like our MailChimp, our Linktree. I mean, would a best practices sort of manual be, should that be part of a bylaws, or should this be more of like an employee manual type of document?
Yeah, excellent. I understand. And I've seen that situation way too many times. And I can make some comments and suggestions, but yeah, I get how hard that is. Thank you, Stacy. Roger?
Yeah.
Sure. I want to thank you again for your last presentation about fiscal sponsorship. And I'm back for another bite at the apple for my my 501c3 fledgling organization. The question is the fiscal sponsorship, or where does the fiscal sponsorship policies and procedures fit into that hierarchy that you so brilliantly gave us all the way down to the very bottom? Do those need to be in the bylaws? Do they need to be in the articles? Do they need to be somewhere specific? that they can be retrieved simply. I get the feeling that those procedures are not simple. They're not you know, they're very detailed, and I doubt that they go in the bylaws, but I thought I'd better ask.
Good question. Okay, I can answer that for you. And finally, looks like Stephanie.
Oh, yes. Thank you very much. I have several questions. One, our neighborhood association is not a 501c3. So Pam, do you remember, what is it? Pam and Nancy, what are the neighborhood associations if they're not 501c3s?
You're incorporated as a state-based nonprofit, but you don't have 501c3 federal tax exempt status. So Southeast Uplift has that tax exempt status and serves as your fiscal sponsor. So you're a state-based nonprofit, but still
We
nonetheless need
We
to
don't have any nice numbers and letters like 501c3.
I'm gonna let David answer that.
Good question. Well, that's actually a great place to jump in with this. Let me start with that, Stephanie. By virtue of incorporating at the state level, you create a nonprofit corporation, and then you are a nonprofit. And whether or not you have tax exempt status is a completely separate, different issue. And so in order to have a nonprofit corporation, you file the articles, and then certain responsibilities and obligations flow from that due to the, again, Chapter 65 for nonprofit corporations. And so you have to have directors and a board of directors, you have to have bylaws, you have to have certain officers. Your bylaws should state that there must be at least 3 officers. Now it used to be 2, president and secretary, and then recently we got the Oregon Nonprofit Corporation Act updated, and one of the changes was to add the requirement there must be a treasurer. And previously, one person could serve in both president and secretary, although it's not a best practice. It was legally allowed. Now that they've added treasurer through the legislature, one person cannot serve all 3 offices. So you have to have at least 2 of those, which is a good, again, for checks and balances in your governance and all of that. So when you create a nonprofit corporation by filing those articles and declaring, you know, is it a public benefit or a religious or a mutual benefit? What type is it? That tells you what part of the statute you have to follow, in this case, public benefit. And because public benefits can go on to get 501c3 status, even though they're not required to, the rules and registration requirements and reporting for the public benefit nonprofits are more strict, more rigorous, more scrutiny than either of the other 2 types of nonprofits. The mutual benefits, which are not organized for the public, but rather for their own members, like riding clubs, chess clubs, social and recreational groups of all types, or alternatively, business and social groups, the social business and trade industry groups. The social and recreational groups can go on to get 501c6 status if they, C7 status if they wish, and the trade associations and professional groups can go on to get 501c6 status. But at the beginning of it, they're just a nonprofit corporation by virtue of having filed their articles with the Oregon Secretary of State's office. So once you have set up your nonprofit corporation like that, you have the choice. Do you want to go on to get your own tax exempt status or not? And if you choose to, then you go through the IRS application process. If you choose not to, then you have a couple of choices there, and that is you can get a fiscal sponsor like Southeast Uplift, and they allow you to use their 501c3 tax exempt status to help you receive grants, major donors who want to give money but want to guarantee tax deduction. If you don't have your own 501c3 status, then your fiscal sponsor provides a way for you to nonetheless receive that kind of funding through their 501c3 status. So the answer is there are no nice federal tax numbers. You're not a 501c3, 4, 5, 6, 7, 8, or 9, or all the way up to 20, but you are a nonprofit and and operate as such. As I said, there's 2 options if you choose not to get your 501c3 or other tax exempt status, and that is it is actually legal, though rare. It is actually legal to operate as a taxable nonprofit, in which case you are a nonprofit. You have to follow all the rules in Chapter 65 for how you operate and how you're governed and all of that. but you are not tax exempt, and instead you're treated by the IRS and the Oregon Department of Revenue as a taxable entity, like a business, but a business with within a nonprofit context. There are reasons why some groups will choose to do that. For instance, if you were going to work with a group that wanted to provide public benefit by helping people who were incarcerated and have criminal records due to the cannabis laws, and if you wanted to form a nonprofit to help those people, and the way you choose to help them is help them to be able to develop their own cannabis-related businesses, well, the IRS has taken a position that you cannot get tax exempt status for any nonprofit that promotes the cultivation, harvesting, sale, or use of cannabis, because it's still illegal on the federal level. So if you wanted to set up that kind of a nonprofit, you would not be able to use a fiscal sponsor, because that's not an allowed activity they can do. You can't get your own C3 status, but you could set up a nonprofit to do that work, and you could then be treated as a taxable nonprofit. And I can give other examples as well for why you might have a taxable nonprofit. But again, that's rare. And frankly, most nonprofits by far, if they bother to incorporate and get started, they're going to go on to get their own 501c3 status ultimately. But it's often really helpful to have a fiscal sponsor like Southeast Uplift or many of the others who will help incubate, help you learn the ropes, be able to get started, help you with your financial management, your organizational management, until you feel that you're ready to head out and take care of all of that on your own. And so you can choose to wait to get your fiscal sponsor, to get your 501c3 status and use a fiscal sponsor, but there's no time limit. Some groups will have a fiscal sponsor for many, many, many years and see no reason to change. Okay, Stephanie, was that enough of an answer for
Yes.
what you are if you don't have your 501c3?
That was good. I just wanted to verify, we are tax exempt, right? No.
Nope. You are using a fiscal sponsor to be able to raise money that needs tax exempt, tax deductible status, but your organization itself is not a tax exempt nonprofit.
But what does that mean for us? As long as we have a fiscal sponsor, it doesn't have a meaning unless we engage in the kind of activity you were describing.
Right. And interestingly enough, it depends on which type of fiscal sponsor arrangement you have. There's two main types of fiscal sponsor relationships. One of them is the project model of fiscal sponsorship. And that's where the organization is actually a project of the fiscal sponsor, is part of it, is governed by the fiscal sponsor's board of directors, has to follow the fiscal sponsor's rules, policies, all of that. They're an integral part of it. In which case, if they've done that, they didn't incorporate separately. They are part of the fiscal sponsor. And in that case, they are tax exempt because they are part of a tax exempt nonprofit. On the other hand, if you are if you're already incorporated and operating as a separate corporate entity and don't get your tax exempt status, you can receive funds from, again, foundations and major donors and others through your fiscal sponsor. But if you're not tax exempt itself, then there's a possibility that the IRS or the Department of Revenue might say, okay, time for you to start filling out your tax forms as a taxable nonprofit that is nonetheless operating with a fiscal sponsor through what we call a grantor-grantee model, meaning your fiscal sponsor, like Southeast Uplift, acts as a grantor, raises money with your help, and then makes grants to you. And so if that situation goes on for longer than 27 months, which is the deadline for filing your own application for 501c3 status, then the IRS right now, generally for most applications, if you have to use what's called the full 1023 application process, will add another 8 to 10 months to that. And so during that whole initial time, you're fine. But if you do not then apply for your own 501c3 status at that point, there's a technical possibility the IRS or the Department of Revenue could say, okay, we want to see corporate tax returns. I'll be honest with you, however, if you're incorporated as a nonprofit and have a fiscal sponsor, it's really, really rare for them to care about whether you are filing the ordinary corporate tax returns.
Thank goodness. Okay.
Yeah, I agree.
All right. Well, thank you, Southeast Uplift and David Atkin, for fiscal sponsorship and explanation. Thank you.
You are so welcome, Stephanie. Which leads us to Roger's question. What about that fiscal sponsor relationship? They can be very helpful. As I said, there's two types: the project model, where you, instead of forming your own nonprofit, you go to an existing one like Southeast Uplift and say, hey, will you take us on as a project of yours? Now, I think Southeast Uplift doesn't do the project model. You do the grant or grantee model, right? Yes. And so that's the other choice. You incorporate, but you go to them and say, would you help us receive funding? And it can also include financial management, organizational management, project management, all those kinds of services as well. And Roger's question was, where do we put down all the details of that relationship? Does it go in the bylaws or the articles? And the answer is no, it doesn't. The arrangement you make with a fiscal sponsor and between a fiscal sponsor and the sponsored organization is a contractual matter. And so we talked about your own organization documents are the articles, then the bylaws, then the policies, and then contracts and agreements. So this arrangement, all the details of it are going to be laid out in a fiscal sponsor agreement. Shorthand, we in the field call them FSAs, fiscal sponsor agreements. And I've helped, literally hundreds of organizations over the many years write customized fiscal sponsor agreements, FSAs, for what services they want. And so the fiscal sponsor itself, the main part of it is they provide your 501c3 status. And then it's a negotiated matter. What other services do they provide? Do they do your bookkeeping? Do they do your reporting? Do they keep your bank accounts reconciled? Do they pay your bills? Do they provide project management? All of those are negotiated out and put into that fiscal sponsor agreement between the sponsor and the sponsored organization. Because Southeast Uplift has a whole program of doing this, then they have a policy that they follow, a board adopted policy they follow for how they do their fiscal sponsorships. And then all of the sponsored organizations have a contract with them that is for their part of it. So when you're the sponsored organization, you don't really need a policy on fiscal sponsors. You just need a fiscal sponsor agreement. Roger, does that answer that question well enough?
It does. I guess I'd have to do a follow-up though and say that sounds like it really requires some attorney drawing documents, or if the policies are, if there are templates available anywhere to facilitate that kind of agreement. When you draft something like that, David, is it usually a time-consuming event, or is it more of a explanation to everybody of what's going to happen or what we hope will happen sometime?
Yeah, it's really more the latter. It lays out the agreements on who's got what roles and responsibilities and obligations, who's going to do what, who's going to keep the books, all those kinds of things. And so a well-organized fiscal sponsor organization like Southeast Uplift will have templates that it uses and follows, and that will allow them to be very organized and make it an easy process. When we write fiscal sponsor agreements, we basically tell the sponsoring organization and the sponsored organization that they need to do the hard work of figuring out what is going to be in the FSA. Is the sponsor, again, going to keep the books, do the reporting, reconcile the bank accounts, is going to thank the donors with donor receipts. And so the two organizations need to work that out. And then I can simply have a meeting and say, okay, who's going to do what? Tell me what it is, and use one of our templates that's appropriate for all of that and come up with a fiscal sponsor agreement. But it's not particularly time consuming because we've done so many of them that we've got provisions that we can add in and take out, like, ingredients in a cake. If you want to do this, we've got a provision written up for it that we add to the template. If you don't, we'll take that out of the template. Does
That's,
that-
that's,
does that
that's a
help,
good
Roger?
explanation. Yeah, and time-wise, it does make sense. And it's a goal. It's a goal that we want to do for organizations that can help the community. So thank you very much for kind of elaborating on what we did last week or whenever it was. That was a great presentation also.
Oh, thank you. Thank you. And thank you for coming back for that other bite of the apple here tonight. Okay, Stacy. Oh, that situation you're talking about where the person just wouldn't turn over the keys to your kingdom of digital online presence. I've run into that way too many times. It's not something that the bylaws can deal with. It's not really something that you can easily, even if you have a policy saying any board member who resigns must do the following. And you can even get them to sign, a board member agreement statement that says upon their resignation or the expiration that they'll turn over all the following. But the truth is, if someone decides they're not going to do it, then it's really hard to force them. And, it starts with just people who know them on the board or the board president calling and saying, wow, you really can't withhold those things. They are our property. It would be illegal. It's a form of theft for you to keep our credentials from us. That's a form of intellectual property that we own. Please get it back to us within 10 days. We need to have it. And if they don't, then you write a letter. And then if that doesn't happen, then you send a letter from an attorney that says, you must return these. This is a form of theft of our property. We will have to take legal action to get it from you. And if they still don't do anything, then sometimes it actually does end up going into a court case. Not often. Usually people don't hold out that long. But ultimately, that's the final thing that can force them to do it. But again, it's not really a bylaw issue, but it wouldn't hurt to have a policy stating that if you've run into that problem before. The ultimate fix is, of course, to make sure that you have a backup of every single credential in a key pass or some safe place that only certain people can have access to, and you've backed it up somewhere else so someone who has access to it can't close it off, change the password, keep it from you, etc. So backups and redundancy and digital security safes for storing your passwords. Stacy, that wasn't the best answer. The answer we'd all like to make it easier, but that's where we are.
I think we kind of all came to that conclusion because we were at the point, like we did eventually get every password about 10 hours before we were going to send the letter from the lawyer. So yeah, so we went, everything that you described, we did get to that point. So we learned our lesson, and the suggestions that you made are exactly what we are putting into place right now. And anybody could run into this situation, not out of someone hijacking or holding the information, but if something were to happen to a board member and they become incapacitated, or the most terrible thing, if they became deceased, we would be without that information too if it hadn't been backed up. So we are actively putting things in place so that never happens again.
Yeah, good. Yeah, and I have to say you're exactly right. I have had just once a situation in which a key player in a nonprofit that had existed for 20 years, and he'd been the president of it's a large organization for 20 years and died unexpectedly, holding all of their digital property in his own home computers that no one could break into. Huge problem. Failure to back up, make redundant, have safety policies that for your digital work can lead to huge problems. Okay, Ute, I see that you are the registered agent of the League of Swedish Societies of Portland. Good for you, an organization created all the way back there on March 15th of 1957. So an organization with a lot of good history. And the question that you asked is, do you still have to even have bylaws? What's required? And the answer is, even though you're not tax exempt, you are a nonprofit corporation. And so as a nonprofit, then all of Chapter 65 applies to you, which requires then Even if you're not tax exempt and don't have 501c3 status, you must have a board, you must have officers, you must have bylaws, and you must follow the rules in there in the statute. I see that you're an organization with voting members, and so that then requires that your bylaws have to not only cover, you know, the board and how they're elected and how long they serve, what terms of office, do you have term limits, how does the board make decisions. A group of voting members then has to have a whole section in your bylaws for specifically what do your voting members have the power and right to do. And so your bylaws will be longer if you have voting members, because you've got to have a whole section that then covers what's the quorum, what's the notice periods for different kinds of meetings, how do they make decisions, can they vote by email, can they vote by mail, can they vote by proxy, all of these different decisions, who's eligible to be a member, how do they become a member. So adding members requires a significant expansion to your bylaws. When we write bylaws, I sometimes hear people say, wow, these are kind of long and a little complicated. Can't we have a short, simple pair of bylaws? And so the answer to that is, yes, you can have bylaws that are 4 pages long, but the problem is, again and again and again in the statute, it says, unless your articles or bylaws say otherwise, then the rule is, and it gives the rules for all these things on meetings, notice, quorum, decisions, who can do what, all of that. And so if you have a nice, simple, short set of bylaws that are 4 pages long, your bylaws actually consist then of your 4 pages and another 150 pages of the Oregon Nonprofit Corporation Act. And the problem is you never know when you're supposed to be looking to see, does the statute cover this or cover that? It's not in our bylaws. And so short, simple bylaws really don't do you a service, because they leave you in that limbo of not knowing what the rules really are, because they're hidden throughout the statute, and sometimes quite hard for even attorneys to find if they're not really familiar with the statute. So yes, you have to have bylaws, and you want them to be thorough and complete so they contain all the information you really need to know in order to operate effectively.
Thank you. Yes, that's good to know.
Yeah, good.
Ours are about 17 years old, so it's about time to do something about it. Yeah, and that's already an amendment.
Yeah. Okay. Well, a couple things to note. One would be the statute was indeed updated just recently, within the last couple of years. And when it was updated, some changes were made that affect probably nearly all of the nonprofits you're with, any of you are with, including your public benefits, but also mutual benefit and religious organizations. One of the changes that was made was it gives more flexibility for what are the rights you want to give to your voting members. Previously, the law said basically that if you have voting members, then they must have certain rights, and the rights would include the right to elect directors, the rights to remove directors automatically. And now with the change, it gives more flexibility. It kind of sets up a buffet. You can decide from a list of things what you want your voting members to have the right to do. The way that the law is structured and the way the whole nonprofit sector is structured is that everybody expects that it's the board of directors that manages the financial decisions, the operating decisions, program and activity decisions of the nonprofit. But if you have voting members, ultimately they control the nonprofit if they have the power to elect and remove your board. So kind of like our model of democracy here, you and I get to vote on who's going to represent us in the state legislature. So we're the voting members, in effect, of the state legislature. We can vote on to elect them and vote to remove them, but we can't go sit down in their chair and cast our vote on legislation that's being formed in the state legislature. So in that way, the board of directors is like a legislative body, and the voters, the voting members, control them by the power to decide who's going to be on that board and to elect them and remove them. So the law used to require that. Now the law simply says, unless the articles of incorporation or bylaws provide otherwise, then the members of the corporation have the right to elect and remove directors, but it's no longer a necessary power that they must have. They also can be given the right to elect and remove the officers. And in many membership organizations, that's common, for especially in mutual benefit groups, either the trade associations or professional groups, 501c6s, or the social groups, 501c7s. The members often elect the board and the officers. In the public benefit nonprofit corporation world, which is what we're talking about here, even with voting members, it's most common that the voting members elect the board, and then the board itself decides, well, okay, who's going to be the president this year? Who's going to be the secretary? Who's going to be the treasurer? And I think it's often because there's a sense that the whole board may do a better job of figuring out who has the time, talent, aptitude, experience, knowledge to be a good treasurer, or be a good corporate secretary, or be a good president. And so it turns it not from so much of a kind of a blind election as the election of a big voting membership can be on that. So you want to look at your bylaws and make sure they actually clearly state what are the powers, rights, and responsibilities of your voting members. Now, there's two things that you cannot take away in the bylaws from your voting members if you have them. One is you cannot take away their power to be the ones who must approve any amendment that would reduce or eliminate the rights of the voting members. So if your bylaws say that the voting members shall have the power to elect and remove the board can't change that. It would take away a power of the voting members, and only the voting members themselves can do that. Or if you wanted to eliminate voting members, the board cannot make an amendment that simply takes out voting members, because that again would reduce or eliminate the members' rights. And so only the voting members could make those kinds of changes. The other power of voting members that cannot be taken away is if you have them, then they have the right to inspect and copy a great deal of corporate records as part of their job to elect and remove the board, or whatever role they have. They need to be able to see what's going on. And so they have the right to see, and the statute has a whole list of the kind of records, minutes, financial reports, article bylaws, other kinds of records of the members themselves and how to reach the other members. All of those are things that the members always have to have the right to do, and the board can't take that away no matter what. Okay, so if you have voting members, your bylaws should cover quorum, should cover such things as the way that you take action and make decisions, how you call meetings, notice periods, all of that kind of thing. So it's good to kind of look at your own bylaws and make sure they cover all of those things, and that they cover it in a way that is in compliance with the statute's default settings. Any questions about any of that discussion of voting members and some of their rights and responsibilities?
David, I just wanted to, I noticed there was a question in the chat. So I just wanted to point out, UP&A includes businesses, institutions, and sheltered and unsheltered residents. Are there objections to businesses being on the board with the IRS? And then there's a follow-up to that. And then the
yes, okay.
Yeah.
Good question. So the answer is the Oregon Nonprofit Corporation Act allows legal entities like organizations, other nonprofits, business entities to be members of a public benefit nonprofit corporation, or a mutual benefit, or a religious. So yes, the voting members can be legal entities. However, the statute says that board members must be actual human beings. In the law, we have this kind of an odd and funny way of phrasing it. We call corporations and LLCs and others, we call them legal persons, whereas you and I, who breathe and have a metabolism, are natural persons. And so voting membership can include legal persons, businesses, organizations, and entities, but the board of directors can only have natural persons, humans.
And does it, there's a second part to that I think pertains to if a group is a C4 and part of the board, are there conflicts there?
Okay, hang on. Yeah, and it's not at all a conflict to have 501c4s who are a member of a 501c3 nonprofit. There's over 20 different categories of tax exemption that the IRS tracks and classifies. In each category, 501c3, so the only ones of them that are tax deductible, all the rest are all tax exempt. So they're all tax exempt, meaning if they earn money and have money left at the end of the year, they don't pay income taxes. They're tax exempt. But the only one that has tax deductible status are the 501c3s. And because that's a much higher level of taxpayer subsidy, every time someone gives a grant or a donation of $1,000 to a 501c3 nonprofit, there's about $300 less money for state, local, and federal governments to, fix the roads, hire the teachers, fight the fires, run the government, etc. And so at every level, federal, state, and local, and with the regulators, the IRS and the DOJ, everybody feels that the money of 501c3s is like public money. So there's a lot of extra rules and requirements on what they can do and what they can't do. They have to operate exclusively for charitable, educational, scientific, religious, or literary purposes. And each of those has a very expansive definition of what it means to be charitable, or what it means to be operate for literary purposes, etc. All of the arts and the like. So that's a very high standard, and the rule is they must be operated and organized, the law says, exclusively for these charitable and purposes and public interests. Whereas the other nonprofits do not have that same higher level of restriction and prohibitions. So a C4 can do things that a C3 cannot do.
Right.
501c4 can engage in unlimited lobbying, whereas a C3 has limits on its lobbying. And a 501c4 can engage in endorsing or opposing or supporting candidates for public office, as long as it's not their primary purpose or activity. But a C3 can't do any of that at all.
Right.
So,
But what we tried to do is make it so in our policies that we prohibited them from being C4s wouldn't be on the board. Although their representatives, as you said, are natural persons and probably could, but that's sort of how we've structured it so far. The question is whether we should be putting in the bylaws. The other question that we've had that I think is germane to everyone in this group is dealing with electronic meetings, and I hope that you can address that and whether and how it should be addressed in bylaws, etc.
Good. So a couple quick things, and one is you have a policy that says that C4s are not on the board, and actually if you're referring to the C4 organization, you can't have even other C3 501c3 organizations on your board. You can only have humans.
Right.
But it is perfectly fine to have C4 or C3 organizations or businesses in your voting membership.
Right.
The electronic meeting rules say basically that a person is present if they are participating in a board meeting or a membership meeting by any means by which they telephonic, electronic, computer assisted, by any means by which they can simultaneously be heard by the other people participating. And so generally the bylaws will say, and especially for the board, that participation in electronically is considered to be present according to the law. And so someone who is there by speakerphone on someone's at a meeting holding up a cell phone, and your board member who's over in, on the beach in Papua New Guinea, if you can hear them, they are determined legally to be present for the meeting. They count for quorum, their votes count, everything. What you can't do is have someone that says, okay, Tom says he votes yes. You have to, all of you, be able to simultaneously hear Tom for them to be present and able to count for quorum and voting.
Right. And then there's a provision in the Oregon code if you don't have simultaneous communication. I'm thinking of an email vote on a board matter or some similar thing. And I was hoping maybe you could describe that and whether that should be addressed in bylaws or just let it go as being an unusual situation, et cetera.
That's a really good question. And it comes to a difference between organizations that are required to follow the public notice and public meeting laws. The statute has always allowed boards to make decisions through in writing instead of a meeting. And what the statute specifically says is that any decision which may be made at a meeting may be made without a meeting with the signed consent of all the directors in office. And that meant you could send out a motion to everybody and say, please vote on this. And if every single board member voted, and they all voted yes, that passed. Well, before email was common, it was really rare for nonprofits to do this because it's burdensome. You have to, print it all out, stick it in the mail it out to them, hope that they're going to pull it out, sign it, stick it back in the mail it back to you. It wasn't quick. But once email became possible, then suddenly it was easier to make these decisions in writing because email is a form of writing. So for a very long time then, email voting was allowed for groups that didn't have to follow the open meeting public notice rules, because you can't really have the public available to attend a decision made by email. But all the other nonprofits, and that's really 95% of nonprofits don't have to follow the open meeting rules and the public notice rules. So for all of them, they could, and the statute was left unchanged for a long time because the legislators were worried that big decisions involving large amounts of money or assets or projects made by email, maybe people wouldn't be paying enough attention and listening to concerns and criticism of the proposals and the like. And so they left it at unanimous. Everybody has to vote and vote yes. And finally, we were able to update the statute and convince the legislature that actually when people discuss things by email and vote by email, even people who are quiet at meetings will often sit down and write you a page or two of their thoughts. And we don't really need to worry that people aren't paying attention when they discuss and make decisions by email. So we finally got a change that now says, just as a couple of years ago, that when if you want to make a decision by email, you send out a motion. You give a deadline for when people have to cast their vote, which may not be less than 48 hours. Board members can discuss it by email, and when they hear each other's opinions, they can change their vote as many times as they want. And however they vote, by the time you get to the deadline, their last vote is what counts. And then it says that the affirmative vote of a majority of the directors in office is sufficient to pass a motion by email. So there's a special carve out for decisions by email that now simply requires a majority of the directors in office to vote yes. You don't have to convince every single person or wait for someone to, check their email when they're out in the wilds for 2 weeks or whatever. So that was a nice change on email voting. But again, your neighborhood associations and district coalitions and groups that are required to follow the open meeting rules can't use email voting.
David, I
Right.
think Mary had her hand up, and then we had one from the chat that I'm happy to read.
Oh, good.
Thank you hi, this is Mary. Thanks for clarifying that. One of the neighborhoods in North Portland does vote via email, not regularly, but I'd say occasionally. So it looks like they're not following the rules. Because they are using the public notice and public meeting scenario. Just something that came up in a meeting last night was that the board of a neighborhood association wants to meet. It sounds like a visioning kind of retreat. And somebody said, oh, we can't meet in someone's backyard. We're not allowed to do that. And then they also thought they couldn't meet without inviting the public. And I just wanted to this was a board meeting. I just wanted to see what you thought about those two issues.
Yeah, for the first one regarding the location of a board meeting, I think there's some rules in the ONI standards. I'm going to ask Nancy, who is my go-to expert on this, that meeting places have to be open and accessible for the public to attend, and that may limit doing it in someone's backyard next to their barbecue, in a setting in which it is not as public and accessible. There's nothing in the Oregon Nonprofit Corporation Act that would prevent you from having board meetings in people's backyards. And there's nothing in any of the federal rules or IRS regulations that would prevent it. So really this comes down to ONI standards and the open meeting rules. Nancy, what's your thought about that?
I think the accessibility point that you point out is really the relevant thing. If someone can easily access it. There would also need to be the public notice, at least a week's notice for the meeting if they're doing it there. And then the important thing to note is that for board meetings, and this applies to both district coalitions as well as neighborhood associations, the public is required to be allowed to attend, but for board meetings, the ONI standards specifically and very explicitly say that participation is not required. So they can come and be an observer, but they're not, the board does not have to require that they allow them to participate in that decision-making process. That's what the ONI standards say right now.
Yeah.
Okay, thanks.
And of course, as we all hustled to try and figure out how to respond to the COVID-19 pandemic and everything went online, that fit in neatly into the, all of the public notice, allowing the public to attend and all of that by Zoom like we've all done. But you still have to follow the open meeting and public notice rules, of course. Okay, Stephanie.
Okay, so I have a question about holding a retreat. And we held a little afternoon retreat a few months ago that was just board members. And we did not invite the public, but it wasn't a board meeting. We didn't make any decisions. It was just to meet in person and get to know one another and talk about what we've accomplished in the past as a neighborhood association and lay out things that we'd like to do in the future. Now, is a retreat like that, what, a 3-4 hour retreat, is that governed by the same rules? The public must be invited and there must be notification and so on?
I'm going to say no. Interestingly enough, you're required to follow certain open meeting and public notice requirements due to the ONI standards, but it doesn't require that you follow the entire Oregon public meeting open record and public notice legal requirements that binds for all governmental bodies, county commissioners and county commissions and the city councils and all of the other governmental bodies that have to follow the full set. So you're required to make sure that anytime your board is having a board meeting and you're going to be discussing and considering and deliberating and voting or not, that you're going to have, the public has to be able to attend, you have to give notice. But if it's not a board meeting and it's just a group of board members that say, let's actually get together in person and get to know each other, it'll help us be able to work, and you're not there to discuss and do the work of the board, it's not a board meeting, then I think that it's no problem to get together and do that. Nancy, would you agree with that?
Yeah, and a great example of that is, Southeast Uplift has an annual ice cream social. We provide an orientation for new board members, and then we just have a very informal ice cream social. And, that's not a public meeting. We're not making decisions. It's just, as you say, board members getting to know each other. So that we don't consider that qualifies. There was another question in the chat that was going back to the constitution of boards, and that one was, can an organization have a board member that's outside of the state registered?
And the answer is yes. It's interesting. You can have an Oregon nonprofit corporation, and it's perfectly legal and fine if no one on the board is a resident of Oregon. You're not required to have a single person on the board from the state of Oregon. In fact, you're not even required to have a single person on the board who lives in the United States or is a citizen of the United States. I've got Oregon nonprofit corporations with people in 5 different continents, and not a single one of them is either a U.S. citizen or a resident of Oregon, but it's still an Oregon nonprofit corporation, and has to follow the rules and the IRS regulations and everything else. So there's not a requirement there. Interestingly enough, on the composition of the board, this is something I think we run into regularly. There seems to be a general belief out in a large part of the public involved in the nonprofit world that you can't have minors on the board, that they all have to be adults, 21 or older or 18 or older. And that also is not true. The statute and the federal law does not set any age limits. All it requires is that board members must be able to independently understand and perform the duties of a director. on the board of directors. And so there are definitely groups that are serving youth who would like to have youth on their boards. And there are definitely 16, 17-year-olds who are precocious and bright and can totally understand and fulfill the duties of a director. And in rare cases, even down to, 14 and 15-year-olds who are unusually talented, but able to do that. And the law does not prevent it at all. I usually recommend you don't have anyone who's not an adult as an officer, because the officers often have extra responsibilities requiring them to sign for the organization. And if someone can't sign in their own capacity, it makes people nervous to have a minor signing, contracts and things like that for the organization. So it's better not to have them as your officers, but you can have youth on your boards, and many nonprofits choose to do so because they serve youth. There's also no upper age limit, just as there's no lower. But sometimes we have to say, can this person independently understand and perform the duties of a director as we all age? And so there's no lower or upper limit. It's all about, can they do the job? And they aren't required to be US or even citizens or live in Oregon. Nancy.
So I know that you looked at the template that the city has provided for neighborhood associations to
Got it
do
right here.
their bylaws, right? And so could you speak to if there have been any changes to state law that might be out of sync of that? Those date to 2015, and we're quite a ways away from that. So is there anything for the folks that are from neighborhood associations on this training to take away from what might be outdated in their bylaws because of that?
Good question. So a couple things come to mind. One is that bylaw template still says that the officers that are legally required are the president and secretary, which was true until just about 2 years ago. And now it is required you must have a treasurer, and the additional requirement that your 3 officers positions cannot be filled by the same person. So that's an important update to put in everybody's bylaws, and the city will have to catch up to that in their template, because it is no longer, that section or provision in the bylaw template is no longer in compliance with the law. Another change that happened is what we discussed with email voting it's not in the bylaws now, but if you're a group that is not governed by the ONI standards, you may be able to do that. I know there are nonprofits who are members of the district coalition and they're not neighborhood associations. So independently, those members of your district coalitions may have bylaws that allow them to email vote, even though the neighborhood association or the district coalition cannot. So that's another thing to think about. By and large, the template is good, and in most ways complies with the everything that's updated, except a couple things like that. So they're pretty sturdy. One thing I noticed that they retained kind of a now very dated approach. It refers to, you can have a president or a chair and a vice president or a vice chair. And actually, when Oregon adopted the National Uniform Model Nonprofit Corporation Act, which is a very good piece of legislation, it got rid of all references to chair and vice chair in every way. You're required to have a president. You can have a chair, but it's actually a different position. The president is a required officer. It has the president's position has certain legal responsibilities and certain legal powers. And they're the president of the whole organization. The chair, on the other hand, is the chair of the board, is their full title. And it's a different position and not a required one. And it's a position without any particular duties or particular powers. Why would a group have a chair? Well, one, it makes no sense to have a president who is the chair. It's calling them the same thing. You should just have a president. But if the role of the president and the chair is that their title gives them a kind of a soapbox to stand on. Everybody will recognize them as a spokesperson for your organization. And so your president, your chair, and your executive director are the 3 people who can go out and meet with important donors, meet with foundation managers, meet with political officials, meet with the press, and everybody will accept them and their ability to speak for the organization. So with that in mind, if you've got a president, it may be helpful to have a chair so that there's one other person who is available to go out and do these kinds of meetings in case your president is unavailable or sick or doesn't get along with that particular political official or is not the best person to meet with the donor, whatever it is. Having a chair just expands who can be a spokesperson because their title shows it's appropriate. So we want to differentiate between president and chair. They're actually different positions. They're not the same. And you have to have a president. Chair of the board is optional. The statute, as I said, no longer even uses the word chair. And so these days, for the last 20 years plus, we really only see the word chair used most commonly for committee chairs. If you've got, standing committees, nominating committees, financial committees, you'll have committee chairs, but we don't hear that word used for the president anymore.
So you're saying that the neighborhood association should have presidents and they could have chairs.
If they're incorporated, they're legally required to have a president. And yes, then they can also have a chair, but it really is a different position.
So that applies to us, Nancy, Brentwood Darlington?
Yeah.
Okay. Thank you. All right. And I have another question.
Oh, good. Jump right in.
Okay, so in our bylaws, we specify a number of people to represent a quorum, that we must have at a meeting before we can officially make decisions. So over time, our board membership has shrunk. And so we've made little changes to the quorum to make it lower every time that we have fewer board members. But I'm wondering the following. Suppose right now we have 8 board members and we say we must have a quorum of 5. But but we don't have a specified number of board members, we just have an upper limit of 21. Now, suppose 7 people wish to join our board within a 2-month span and we voted them in, or we had an election and suddenly we have 15 people instead of 8. So a quorum of 5 is no longer appropriate, but changing the quorum, changing anything in bylaws is a procedure with notifications and, and I was wondering if it's possible to use a ratio. Suppose right now we say we require a quorum of 5 in a board membership of 8. And if it jumped to 15, we could say 5 is to 8 as X is to 15. And that would be the statement in our bylaws that we have a ratio. And that way we don't have to change the quorum if there are fluctuations in the board membership.
The common practice that's followed literally by over 95% of nonprofits is to state the quorum as a either majority or a percentage, and that way it automatically changes as the board grows or shrinks. And so the most common one by far, and what Robert's Rules of Order uses, which you don't have to use, is simply a majority of the directors in office immediately before the meeting shall constitute a quorum. The presence or participation of a majority of the directors in office shall be a quorum. So that if you have 7 board members, then 4, a majority is a majority, meaning slightly more than half. And we always round up to the next whole human being. So 7, half would be 3.5. You could have 3.6 people be a board member, but it's hard to get 0.6 of a person. So we round up. And then if you have a board of 17, well, then you're going to have 9 board members. It's going to be a majority. So it's very rare to put a number for a quorum. Almost everybody uses a majority, but state law does say that unless your bylaws or articles say otherwise, the quorum shall be a majority of the directors in office immediately before the meeting. But it provides that you can, in your bylaws, shrink the quorum down to as little as 1/3, not lower, or you can go all the way up to requiring 100% quorum, all of the members of the board. So you have a great deal of flexibility from 1/3 to 100%. Almost all nonprofit groups just choose a majority of the directors in office immediately preceding the meeting.
Oh, thanks. That is extremely helpful, and you could get a little clue as to the state of our bylaws, which I think date from the 1970s or something.
Oh, my goodness, you know that there are some big changes in the law. 1970.
Yeah, no, Pam and I especially, we are on track, or hoping to be on track to make all the necessary updates. Yeah.
Good. Yeah, if they really do date back that far, and I work with lots of organizations whose bylaws do. In 1989, Oregon is the date when Oregon adopted the National Uniform Model Nonprofit Corporation Act, and it was a huge change in the law for nonprofits, and a much better law, frankly. And following that, that was kind of the trigger for lots of organizations to know we better update our bylaws now. We have a whole new statute. But some groups didn't, and so that's still something they should get around to. One quick comment is that the law says for your board of directors that for a public benefit nonprofit, there shall not be less than three board members. You can have one for a religious or a mutual benefit, but public benefits require a minimum of 3. And the law says that the bylaws can either set an exact number of board members or set a range by declaring a minimum and a maximum number. And so what most organizations always do, unless they're very specifically need to have an exact number, maybe an organization represents, people of 4 different very specific constituencies, maybe the 4 quarters of the state or whatever. So very rarely a group will say, we want to have only, only 4, only 8, whatever board members. But for almost all, it works out better to just say, a minimum. And the best practice, although state law says 3 is the legal minimum, for public benefit nonprofits with 501, especially with public charity 501c3 status, the best practice everyone wants to see is 5 or more board members. So there's a few more eyes on the ball watching the money and the organization and assets and what it's doing. So generally, when we write bylaws, we'll usually write, there shall be not less than 5 and not more than, pick whatever upper number you want to go to, 15, 20, whatever you want. You don't ever have to get there. If it says not less than 5, you can be 5 forever, but it allows you to easily change numbers of board as people come and go, someone resigns, you have a vacancy you didn't fill. It makes it completely legal for the number of board members to shift if you just say, there shall be not less than 5 and not more than 15 or whatever board members. And then you're covered for all those kind of ongoing contractions and expansions of your board. And of course, then if you say a majority of the directors in office immediately preceding the meeting, then your quorum changes automatically with that as well. Question in the chat here, is it okay if the bylaws use the president and the chair and are identified as the same person? Yes, it's legal to do it as long as you do have a president. And interestingly enough, not all nonprofits and their boards and the people involved in them are really comfortable with corporate law and kind of the what we inherited from England and the legal statutes around corporations. We're gonna have some semblance of everything from colonialism in the past to the patriarchy and everything else. And so some people aren't very comfortable with a lot of the vocabulary of corporations and the like. And so you have to have a board of directors, and you have to have a president, you have to have a secretary, but you can, in your bylaws, say the board of directors shall be known as, pick your name, the council of elders, the circle, the coordinating council. You can decide what vocabulary you want to use as long as your bylaws say the board of directors shall be referred to or called, etc. And same thing with your president. You can say the president shall be called the chair. Or you can say the president the president shall also serve as the chair if you want to keep the clarity about the two positions. I know I deal with one group that's agricultural, deals with agroecology, and they choose to call their president their top tomato in their bylaws. Well, fine. You have a president who we call the top tomato. So yes, you can. It's perfectly legal to do all of that, and you can be creative in how you choose to name and call your officers and your board of directors itself.
Okay, great, interesting.
So other thing, a note in the chat that Overlook Neighborhood Association uses 1/3 of quorum, and perfectly legal. If it says it in your bylaws, you can do it. And And the other comment is quorum was set numbers. Yeah. I don't have problem with quorums anymore like we used to have. Now that anybody can pick up a cell phone with a speaker and call anybody anywhere in the world, even if they're on vacation, etc. People attend board meetings if they're needed. And so we don't have quorum problems much anymore when it's a majority, slightly more than half, 50% plus one. And people can attend by Zoom and hybrid meetings and all of that. But if you're having problems meeting your quorum, if it's too high, if it's 3/4 of the board or 80% of the board, then perhaps you do need to lower it back down to closer to a majority.
I see Mary has her
Okay.
hand up too.
Yes, Mary Jaren?
Hi, so, we're all coming out of COVID and people not meeting in person and just, it really wreaked havoc on neighborhood associations and, just general engagement. So from, looking at some of the neighborhood associations in North Portland, they are recovering, and they either lost board members or can't, or are having trouble recruiting them, having trouble, voting because they can't, meet quorum. There's one in particular, maybe two, they just tried to elect a treasurer and, no one agreed to it. They said, no, thanks. So what is what would really happen if these if someone, I don't know who's going to find out that they only have a president and a secretary, or what could, these groups don't have much money. They're doing basically nothing. They're meeting maybe once a month. Maybe there's a cleanup or something. And I'm just like thinking generally now.
Yeah.
So yeah, I see that they're struggling, and we could call them inactive, but they're actually trying to gain more members. But there's so many challenges, and I don't, everybody on this Zoom call knows what I'm talking about. So David, I can't scare folks. I don't want to do that, but how do we support them? I mean, yes, I can say you must have a treasurer, but if no one is willing to do that, what's going to happen to groups?
Yeah, good question. And generally speaking, if you're violating that kind of a requirement from state law and your own bylaws, it creates a vulnerability. And that vulnerability is partially optics. People then can criticize and say, this organization isn't following the law, they're violating the Nonprofit Corporation Act, they're not following their own bylaws, their board isn't legitimate because of that. And so it can damage the reputation and the credibility and the legitimacy of the organization and the board in the eyes of its public, its members, its donors, and the likes. But there's not this moment, there's not a state agency that's going to come out and say, okay, you have 5 days to find someone who's going to be your treasurer. When the law changed to require a treasurer, the Oregon Corporation Division, part of the Secretary of State's office, told us that, okay, it's going to take them a while to change their entire database and website to start tracking president, secretary, and treasurer. And once they start tracking that, as the law requires, there must be a treasurer. Then the Secretary of State's office might say, we can't allow you to operate without filling all 3 required offices, because we have to show on our website who they are. Currently, though, it's just president and secretary. So generally speaking, no state agency is going to know. And even if they did know, they would say, work on it, try and do better. And that's about as far as it would go. So it really has more to do with the organization's credibility, reputation, legitimacy.
Okay, thank you.
Yeah. Okay, one of the other things I wanted to also just cover briefly is we've talked about membership organizations, which is especially relevant to this group of people and the organizations you're involved in, where there's voting members who generally do elect and remove the board. There are, however, 5 different ways that people can be on the board of the directors. And so you can be quite creative and you can mix and match all of them. So generally speaking, in the public benefit 501c3 world, most organizations have the board of directors elect their own new directors, and they don't have voting members, and that's perfectly legal. Second, then, would be the groups with voting members. Almost all of the mutual benefit groups that serve their members have voting members who then elect and remove the board. It kind of goes with the territory. It's very rare, but legal, to be a mutual benefit without voting members. But with neighborhood associations and groups like this who are representing certain constituencies, you want to give a democratic process for deciding who's going to be leading the organization as the board. So most public benefits have the board do self-electing boards. Then we have the groups like these you're in that have voting members that elect the board. You can also have people on boards, and it needs to say so in your bylaws, who are there because some other group, agency, or person has the power of appointment. And so you could say that, a certain official, the mayor's or his or her designee, shall have the power to appoint one member of the board of directors, or the president of the college, or whatever you want. So you can give power of appointment, or to other agencies and organizations you're closely connected to. And so you can give other organizations their board the power to appoint one member of your board. So we have power of appointment. And so the neighborhood associations appoint people to the district coalitions through that power of appointment. You can also have a 4th one called ex officio. And that's where someone is serving on the board as an aspect of the office they serve, the job they do. And there's kind of a misconception that ex officio board members don't have the power to vote. They're not really real board members, they're honorary. But that's not true. It's just ex officio just describes how they got on the board in the first place. And so you can have a board with some people who are elected by the members, and some of the directors are elected by the members, and then those directors themselves elect a couple more people. And then there's a person or two on the board who are there by power of appointment by other groups you've decided to give the power to appoint. And then you can have someone on the board who's because of the office and position they're in. And the final one is you can actually have designated directors. Designated directors are people named by name in the articles or bylaws who are going to be members of the board for so long as they wish and have not resigned and can fulfill the duties of a director. So they are kind of permanent board members unless you amend the articles and bylaws to take them out on that. Elected board members, whether they're elected by the board or by the voting members, have to have a term of office, and that cannot be any longer than 5 years at a time, and then they have to be re-elected to stay on the board. There's no requirement for term limits. You can simply say board members may be elected for subsequent terms of office with no limit, or you can decide, 3-year terms and no more than 3 consecutive terms. That'd be 9 years on the board. So lots of options for how people get on the board and how long they serve. If they're there with power of appointment, ex officio, or designated, they don't have a term of office because they weren't elected. And so they are not restricted by that 5-year term of office, need to be reelected. Okay, we have just a couple more minutes or one. Any last question from anybody before we wrap this up? Stephanie.
I don't have a question. I just wanted to say that I was dreading this meeting, but you've made it so fascinating and so accessible and interesting that I am full of gratitude. Thank you.
Thank you so much for saying that. You are so welcome. As I said, it's a pleasure to get to be here with you. It really is. And I like bylaws. I can talk about them for a long time.
If I may just briefly ask you one more time, this is Ute again with the League of Swedish Societies. Would you repeat the year again, and where did you find it when the league was established? Because I have heard a different number or year And I would like to have something that I could put my thumb
Sure.
on, say.
You can find
whatever
out
I
a
heard is
wealth.
wrong. I'm sorry.
You can find out a wealth of information about any nonprofit corporation in the state by going to the Oregon Corporation Division, and it's called the Business Registry. And it has and lists the history of every corporation, LLC, entity that's ever been created, and gives the assumed business names and everything else. So I looked just real quickly, checked in and saw that the League of Swedish Societies of Portland was originally incorporated on March 15th, 1957, that it's a public benefit corporation, that it has members, that you're the registered agent. I know the name and address of your president and secretary, and your principal office. I see that you've never, an organization, this is an organization that's never had a different name. Many organizations have had 3 or 4 names if they've been around that long. They just change them every few decades and add or subtract a word. And I can look at the the annual reports that you've been filing for every year, and see who the changes in your officers were. And I can look all the way back to see, were you ever dissolved because someone forgot to file the annual renewal? And I see, yes, why back in 1984, you were dissolved, your organization was dissolved, and then reinstated very shortly after the next month. So you can find, and if there were articles of amendment ever filed, amending your articles, I can see those. Restated articles. So if you go to that Corporation Division website, it'll give you lots of information about your organization and everybody else's as well.
And what is that? What is
I
that path
appreciate
again?
that.
That's Secretary of State.
I
Yes,
put the link in the chat.
Oh, thank you.
Thank you.
good
And
job,
also,
Nancy.
I also wanted to shameless self-promotion for other opportunities to have trainings such as this is I dropped the link to our most recent e-newsletter. And if you click on that link and scroll down, there's a whole bunch of, we've got financial trainings coming up. We have a whole fundraising series. We just invite the community to participate in them. So David, thank you. Thank you so much for being here and sharing your wealth of knowledge. You're always a treasure trove of information that is so helpful.
You are so welcome. Okay, take care, and thank you all for being on those boards and being involved in the organizations you're with. You're a credit to our communities and a blessing. Thank you for that service.